And the issue was that this caused the Me Too movement to come about, or really more popularized it. And then you saw a slew of people in the C-suite seats getting fired, leaving to pursue, quote, personal interests, and those kinds of things.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, I talked to Miami law professor Marcia Narine Weldon. We cover drafting a Harvey Weinstein Clause and how this clause helps companies manage the risk of large sexual harassment settlements and public relations disasters. Marcia takes us through several examples of the Weinstein Clause in practice. Let's tear it down. Now, Marcia, what we're going to talk about today is something that's been on your mind. I'm going to share my screen here for a second because this is a bit unusual. Usually with a Contract Teardown Show, we just run down a contract. In this case, we're going to focus around an issue that seems to have been bugging you. Specifically, you wrote a couple of blog posts on this issue, the Harvey Weinstein Clause, they call it. But specifically, we're going to end up going through this prospectus. It comes from a merger between Noble Energy and Chevron, if I've got that right.
Correct.
And specifically, we're going to go down to these clauses, these representations about sexual harassment down here on page 22. We'll make sure that you guys have access to those documents. So if that sounds like a plan, Marcia, that is what we're going to do. What is this Harvey Weinstein Clause? When are we going to run into it? Why does it matter to lawyers? Why should we pay attention to it?
Okay, so the Harvey Weinstein Clause came about 2017, 2018, more so in 2018, after Harvey Weinstein infamously was accused of sexual assault, harassment, rape by, I don't know, at this point, probably hundreds of women, but at the time, fewer. And the issue was that this caused the Me Too movement to come about, or really more popularized it. And then you saw a slew of people in the C-suite seats getting fired, leaving to pursue, quote, personal interests, and those kinds of things. So the question was, in the context, leaving to pursue personal interest is really code for fired. But as a former employment lawyer, I can say that, right? But the issue was people were getting into deals and they weren't really sure about the background, right? So when you get into a deal, you're going to merge, you're going to do an acquisition, you do a whole lot of due diligence. You know about the balance sheet, the financials, the cash flow statement, environmental issues. You know about labor issues. You know if there's strikes. You know how many harassment cases there are. But they don't really ask a lot about the executives. Now, you may see who's in the succession plan. You're going to know their CVs, that kind of stuff. But this really raised the issue of what about harassment in the C-suite or those that might get to the C-suite? Because you saw people like Les Moonves, Steve Wynn, so many high-profile people, founders of companies having to leave. So some M&A lawyers started saying, we're going to do some reps and some warranties in these documents to make sure that we're protected. So just like you're going to rep that there's no outstanding material litigation, other than what's disclosed on the schedule, no environmental litigation, those kinds of things, you're also going to say there's been no allegations of harassment.
Right. Yeah. I mean, as soon as that risk became present to people, companies started to pay attention to how to adjust to that risk. So this bit comes from, that I'm sharing now, Marcia, comes from a document between Salesforce and Tableau that you pointed to. It says, to the company's knowledge, in the last 5 years, no allegations of sexual harassment have been made against any employee at the level of vice president or above, and neither the company nor any of the company's subsidiaries have entered into any settlement agreements related to allegations of sexual harassment or misconduct by any employee at the level of vice president above. What about this drew you to this issue? What in this language really drew your attention?
There's a bigger picture, right? So I'm a law school professor now, but I've also been an employment lawyer since 1996. On the defense side, from an employment law perspective, I've done training on harassment, I've written policies, I've defended litigations. So there's so many different words in there that could cause questions. So what is sexual harassment? It depends. Are we looking at what the courts say when they're looking at Title VII? Right? Title VII talks about sex discrimination. Sexual harassment is an offshoot of sex discrimination. Are they looking at what the EEOC says? Are they looking at what the 11th Circuit says? Or are they looking at what the employee handbook says? Now, if you're writing an employee handbook, you're going to add a whole lot of things that that might be what you call violations of your company policy, you'll have the language about sexual harassment, discrimination, but you're going to add a lot of things that from a legal perspective, I can win on a motion for summary judgment or a motion to dismiss that wouldn't be cognizable sexual harassment under the law, right, but might be a violation of the policy. And the policy is always going to be broader, or generally going to be broader. So what does it mean for sexual harassment? What does an allegation mean? All right, so companies are required to take any allegation, no matter what the channel is. Once the supervisor knows, the company knows. So if I say to you, hey, I think this guy's been harassing me, is that an allegation? What if it's not recorded? What if you have a document destruction policy, and this is an allegation that happened 10 years ago? The employee has now left the company. So how do you look at all of those things, practically speaking? And how do they actually know? Do they then go out and put a newsletter out saying, by the way, we need to know if Mike Whalen has ever harassed you? If you never reported it before, let us know. Or if you reported it and you thought it got swept under the rug, let us know. If you reported it and you didn't like the investigation, let us know. Because, Mike, you might be a serial harasser. We just could never prove it. So
you'll never catch me, fast as fast can be. Well, and relatedly, in the Salesforce and Tableau document, it gives this definition of knowledge, which is really interesting, because some of the things we'll talk about later talk about like standards of investigation and reasonableness, which is interesting. But in this case, they say knowledge refers to the actual knowledge of a bunch of individuals that are listed out elsewhere in the document. In each case, after reasonable inquiry of those employees of such party and its subsidiaries who would reasonably be expected to have actual knowledge of the matter in question. A lot of qualifiers in there.
There's a lot of qualifiers. And of course, I also teach contract drafting. So reasonableness is, of course, every lawyer knows that's that really vague wiggle room. What is the reasonable? Is it a reasonable HR professional? Is it a reasonable outside counsel? Is it the reasonable man or the reasonable woman? I'm not sure what that means. Again, what's a reasonable inquiry? Actual knowledge, I like that. I think that's smart, right? Because actual knowledge means that you actually have to have known it. If I were on the other side, I'd want constructive knowledge. But here's the thing. If you look at what the legal standards are, right, from the cases that come from the Supreme Court, Farragher, Burlington, those cases make it very clear that once, somebody in the company knows, a supervisor knows, then the entire company knows. That's knowledge. So if you, Mike Whalen, you're no longer the serial harasser. You're now the supervisor. You're the low-level supervisor. You're just trying to keep your job. You're not trying to get involved in anything. Somebody says, hey, look, Preston's been harassing me, but I don't want you to do anything about it. We're in a pandemic. I just want to keep my job. I just want somebody to know. You say, whew, good. I don't want to know about it. That's good. You know. Is that actual knowledge for this company? Even if you don't do anything about it? If you fail to follow what you're supposed to do and raise that up to the higher authorities, to HR, to whomever, what does that mean? What if there are allegations that go through the company hotline? They're anonymous. They can't be investigated. Does the company then have to disclose that? We have these allegations of saying, Mike Whalen is a harasser. I'm not going to tell you my name. Please investigate. Because if there's any employment lawyers on this, watching this video, they know that happens often, more often than you would think. Does that count as an allegation? So then what's the reasonable inquiry? Do I look back at every hotline claim that's ever come in? Do I go back and reinvestigate allegations to see if they were really plausible, if maybe there was shoddy investigation going on? So it kind of opens up a real can of worms that I'm not sure that people really thought through.
Well, and one of the things that we wanted to talk about a bit was the vagaries of employee handbooks and codes of conduct. This comes from Noble's Code of Conduct. Remember, we're going to end up talking about Noble and Chevron's merger. And if you look over this, and even Chevron's Code of Conduct policy, it's sort of vague. It talks about, hey, don't do sexual harassment. And everybody's like, good idea. So it's hard to turn this into something enforceable. What's the relationship between documents like codes of conduct and employee handbooks for standards that then turn into a duty for the company to investigate? Does that make sense? Like, what's the connection between what they say and what they have to do?
Regardless of whether they have a code of conduct or a policy, they still have to follow the law. The issue is that the code of conduct is typically a public document, especially for a public company. You have to have it as a public document. The employee handbook typically is not. So Chevron, Noble, all of these companies likely have or hopefully have a much more detailed policy about harassment, discrimination, where do you report issues, what the investigation process is, all of those kinds of things, whether there's a hotline, a helpline, an ombudsman. That may not be visible in the code of conduct. So again, when we're talking about sexual harassment, is it sexual harassment as per the code of conduct? Sexual harassment as per what they were trained on in the training deck? All of those different kinds of things come into play. That again, from a transaction lawyer's perspective, if you don't have an employment lawyer walk you through it, the employment lawyer probably says something like this: good try, let's see if it works. Probably better to have it than not. Right. But would say, but just so you know, in some kind of CYA email, I'm not sure this is really going to hold up, because somebody else is going to come by and say, what do you mean by reasonable? What do you mean by investigation? What do you mean by knowledge? You didn't define knowledge, because some of the clauses, they don't actually define knowledge, which is, does that mean it's constructive knowledge? And again, and because of the way sexual harassment law works, you are presumed, Mike Whalen, floor supervisor, is the company as it comes to person reporting harassment, even if that person says, don't do anything about it. Please don't do anything.
Well, what we're going to do now, because on this show we like to tear apart specific language, you gave a bunch of examples in one of your blog posts, and I want to go through some of those, and then we're going to end with the piece, the Noble and Chevron example, and then try to pull some principles from all of these different samples. So let me start with the first sample. I'll read it to you, and you tell me what you think about it. This comes from a merger between Genuine Parts Company, Rhino, Spinco, etc. It says, to the knowledge of GPC in the last 5 years, no allegations of sexual harassment have been made against any current Spinco business employee who is an executive officer or at the level of senior vice president or above. Good, bad, what do you see there?
So, again, I don't know how deep the vice president, executive vice president ranks go, right? So if there's only 5 of those people, hopefully you don't put that out there without doing, some social due diligence, right? You have to go out and kind of ask some questions. Hey, have there been any murmurs, any rumors, those kinds of things? Because otherwise, you're going to get slapped in the face. What I've always wondered when they put positions, especially very high positions, is why do they limit that way? And do they have a succession plan? So what happens, I also used to be an HR professional. In the succession plan, what happens if Mike Whalen gets hit by a bus? Who's going to take over, right? So you typically go a few levels down. What if you have a bunch of harassers at the levels below that you haven't taken care of, and they're the superstar employees? So what do you do in terms of that? So are you limiting that line because it's just easy, or is it because you know something else? When you talk about the last 5 years, I hope you've thought about that. Is it because something happened 6 years ago and you did your cleanup, and so you're sure from the last 5 years? And again, depending on how big the company is, if it's some worldwide conglomerate, how do you know?
Right.
How do you really know?
Yeah, to the best of our knowledge. So I've got another sample here I want to read to you. This one comes from WordStream, Ganetco, Orca merger. It says the company is not party to a settlement agreement with a current or former officer, employee, or independent contractor of the company or its affiliates that involves allegations relating to sexual harassment or misconduct to the knowledge of the company. In the last 8 years, no allegations of sexual harassment or misconduct have been made against any current or former officer, employee of the company or its affiliates. It's longer. Does that make it better?
No, sometimes the longer it is, the more you have to talk about, right? So right. I don't know what sexual misconduct is. Did they define that? So sexual misconduct, there's a Christmas party. Let's do a pre-COVID land. Christmas party. People are drinking at somebody's house. There's a mistletoe. Somebody kisses somebody they didn't want to get kissed. Is that sexual misconduct? Might be. You got to disclose it? Maybe, if you don't define it, right? So, because by the way, for a lot of companies, that's sexual misconduct. They have training around the holidays, don't drink too much, no mistletoe, all kinds of things will go out because they know people do stupid things when they're drinking at a holiday party, end of the year, that kind of stuff. Does that count?
Yeah, just FYI, I told you at the beginning of our conversation we were going to see if my kids and animals would zip it for another 20 minutes. I hear them stirring. It's 2020, people, so forgive me if you hear any exotic birds squawking in the background. Here's another example. This is an agreement and plan of merger among RJ Entertainment, AMC Networks, etc. It says, to the company's knowledge, in the last 10 years, no allegations of sexual harassment have been made against any officer of the company or any of its subsidiaries. The company and its subsidiaries have not entered into any settlement agreements related to allegations of sexual harassment or misconduct by an officer of the company or any of its subsidiaries. The language is starting to repeat itself. I mean, as is often true in these things, we copy-paste, contract lawyers often copy-paste. So is there something new in this, or are we starting to establish?
10 years is a long time.
10 years is a long time.
So I'm only going to do something for 10 years, because I've also been an in-house lawyer, deputy GC, those kinds of things. I'm only doing something for 10 years if I really know that we've been clean, which means I'm practically doing a deposition of all the HR people, past and present, for the past 10 years. Because, if something was 10 years ago and we've got new people in here now who wouldn't know about it, I'm going to find out. Because again, a lot of companies also have document destruction protocols. Person's been gone for 10 years. If you don't need that person's personnel file, you're going to look at state and federal law, but at some point you're going to start getting rid of files. So how do they know? 10 years is a long time. So I'm going to assume good faith, and these people have the best lawyers in the world. So I'm going to assume that if they said 10 years, they really know 10 years.
One last example, and again, we're getting longer, so it must be good. So whatever patterns we're finding in this, and then we'll talk about the Chevron and the Noble piece. Let me get rid of this first bit of the language, but it says, to the knowledge of the company, no allegations of sexual harassment have been made against any officer or director in the acquired companies, any employee of the acquired companies who directly or indirectly supervises at least 8 other employees, which apparently is their standard for a supervisor, of the acquired companies. And the acquired companies have not entered into any settlement agreement related to allegations of sexual harassment by any employee, contractor, director, officer, or other representative. So in a weird way, they're like going up the ladder and down the ladder. What are you seeing in this one?
It's interesting. I mean, 8 employees is kind of random, but I'm sure they had a reason for it. The contractor language is always interesting to me because companies are responsible if contractors harass their employees. They've got to protect people from contractors. The question would be, is any contract still there that's been accused of allegations? Let's assume there's been no suit or no settlement. And by the way, people often settle even when there's no liability. They settle for nuisance value. They settle because they don't know if they can win the case. They settle because they say, you know what, Preston's a good guy, but he's going to look like a liar in his deposition, right, and Mary Jane is going to look like a saint. We're going to settle this case. So sometimes people settle regardless of the merits just because they want to get rid of the case. If there's contractors, contractors aren't employees, but if your contractors harass people, you need to end that contract immediately. So the minute there is an allegation by about a contractor, you get rid of that contractor. So it's always interesting to me when they have the contractor language in. Again, unless it's the kind of business that depends very heavily on contractors and independent contractors, which itself leads to other employment law issues, which is the subject of another teardown.
Right. Yeah, it sounds like a lot more risk with a lot less control. All right, what we're going to do now is identify the one that you talked about as the good example, as good as it gets here.
That's the better example.
The better example. Well done. Good qualifier, Professor. And again, it's the longest, so this is coming from the prospectus between Chevron and Noble in their merger, and they go back to January 2018, so just a couple few years. To the knowledge of the company, no allegations of sexual harassment or other sexual misconduct have been made against any employee of the company with the title of director, vice president, or above through the company's anonymous hotline, mentions the hotline, or any formal human resources communication channels at the company. So formal. Is interesting. And there are no actions, suits, investigations, or proceeding pending or to the company's knowledge threatened related to any allegation of sexual harassment or other sexual misconduct with the title director, etc. To the knowledge of the company since January, neither the company nor any subsidiaries have entered into any settlement agreements related to sexual harassment allegations with any of those ranks. Why is this one better?
So this one is interesting because the Noble and Chevron story is interesting for a number of reasons. and this was I believe a stock sale, if I'm not mistaken. But in 2017, the general counsel of Noble resigned to pursue personal interests after allegedly videotaping a female employee under his desk. To Noble's credit, Noble took action after they had heard of this allegation, very swift action. He left in 2017. He left with a nice payout, a lot of vested options and those kinds of things. The company did not do a clawback, as the company had the right to do. But it's likely that after that happened, the company did a really thorough investigation. I don't know. I'm just speaking from what I would assume would happen. Because that is a company where many of the hotline calls went into that general counsel's office. So I have to assume that Noble, again, I have no personal knowledge, would have done a very thorough investigation so that they could say, as of 2018, we're good. The other thing is when somebody at that high level leaves the company, it also gives a lot more comfort for other employees to go forward. Look at McDonald's and the CEO and then people that came forward about other things. So they likely feel we've got everything, because if we show that the general counsel can leave to pursue personal interests after this allegation, then other people probably came forward. So that date really makes sense. And I think that Chevron would have wanted that because, again, that's a very high person in leadership who's in charge of the ethics and the legal work of the company. So that's why I think this one is a better one. It looks like it's more well thought out. It clearly took into account the allegations about the former GC. So this one is better. And I think they would have had to do it with a lot more. It seems like they took a lot more care on it.
Right. So what about that distinction before we get to principles between actual knowledge because Supervisor Joe knew versus somebody went through formal communication channels? You like that language better?
Well, as a defense lawyer, of course I like that language better because, right? Because the formal communication, and they talked about their anonymous hotline and HR. So I need to see their employee handbook to see what their formal communications are, right? Because a formal process might also be talking to your supervisor, because the case law has to make that very clear. You have to have some kind of way for people to raise complaints. So can they go through the chain of command? Does that count? So the word formal is interesting to me because without seeing what their handbook says and without seeing what their open door policy and all those things are, it's hard to know why they put the word formal there. But that's clearly a deliberate choice.
Well, I like it. And so to wrap up, what's the principle here? I mean, we talked a little bit about definitions and those vagaries. We talked about how deep you dig into these things. I'm thinking as a transactional lawyer who's drafting these things sort of on both sides of one of these mergers, if I'm the person trying to avoid the risk or I'm trying to be the person who doesn't sign off on, will absorb all the risk in my representations, what kind of principles can we draw from this in terms of drafting?
Well, I think if you're dealing with a company that's had a major sex scandal, you definitely do this, right? These aren't as common as I would have thought. And it's probably because people think, well, how are we going to prove all that if it comes up? Right? And then what's the indemnification, all those kinds of things. But the biggest principle is that you stay in your lane, right? So if you're a transactional lawyer, if you're going to put this in, you got to make sure the employment counsel walks you through all the words that you're doing and pokes all the holes and then says, all right, we're going to put this in there. Because obviously if you have a rep warranty, those kinds of stuff, it's to mitigate risk. So you don't want the company, the acquirer, to have a false sense of security. To say, these are the words that you've chosen. Let me tell you the 10 things this is not going to cover. Or let's make sure we've sat down with their head of HR or whomever it is and said, how do complaints get made? How many of you guys had? What's your positivity rate in terms of anonymous, claims? What's the corroboration rate? Those kinds of things.
That's perfect.
That's what I would do.
The lesson is talk to smart people, just like we did. Thank you, Marcia. If people want to follow up with you, maybe connect with you on social media or whatever to talk about some of these issues, if they want to dig deeper on it, what's the best way to get in touch with you?
You can find me on LinkedIn, Marcia Narine Weldon, and I'm happy to talk to you. I love talking about this stuff. I blog probably every other Friday on the Business Law Professor blog. And this actually came to me because someone from the Financial Times, and the article came out a couple of days ago, reached out to me because you don't see a lot of these. And the question was, why would Chevron do this? They didn't do this with other companies that they bought. Why do it with Noble Energy? And that's how this came about.
We'll make sure that at lawinsider.com/resources, where we're going to post this video, and on YouTube, that you guys will have the links to Marcia's posts, as well as any of the documents that we talked about, so you can access those. We'll continue having teardowns like this. Just go to lawinsider.com/resources. You can look those up. And if you want to be a teardowner, one of the smart people we talk to, just go send us an email at community@lawinsider.com. We'll see you guys next time. Thanks again.
Thank you.